Hi, it's Kip Malek, attorney. Um, First of all, I want to wish you a Merry Christmas. It's December 24th, 2019. I'm here in my office in the morning, so I figured kick off video. A lot of these videos are, I try to think of ideas and topics that will be relevant to people who've had injury. So if you're searching on Google or whatever, and you type in whatever these search terms, it'll pop it up and maybe it'll help you out. At least give you some advice. When I'm looking up, if I have some kind of thing that's bothering me, like, my tooth is bothering me, or maybe my shoulders bother me, I'll look on the internet and be a Google doctor for myself. So this is kind of the same thing. Not really replacing an attorney. Obviously, you should get an attorney, but if you're just doing a quick little research to get some idea of where you may stand on an issue, that's kind of what the purpose of these videos are. So, for this video, I'm going to be talking about something called in the workers' comp realm that you may encounter if you're an injured worker, is the going and coming rule. And so this is like a legal concept that employers or will use to not cover, like, if you have an injury, they'll use it. It's kind of a defense, and essentially, bottom line is, if you have a work injury in Ohio, it's got to be, you have to have an injury, obviously, and then it's got to be causally related to work, i.e., it has to be a result of work in some fashion or reason. So, and the most obvious is you're at work and you get injured at work. You're lifting a box or something hits you at work, something of this nature. So if you're at work, you're in the warehouse and a box hits you, obviously it's a work injury. So the going and coming rule applies when you're not at work and then you have work injury. So if you're not at work but you're kind of doing a task that's related to work, you would think, okay, it should be a work injury, but then it may or may not be, depending on a number of factors. So the most simplest circumstance where it is not is if, like, for instance, I'm Kip Malek and I'm driving to the office down here in South High Street. So I'm driving from where I live, get on the highway, driving to South High Street, and on the highway, I get in a car accident. So I'm going from my house to work, I get injured. So you'd think, well, I'm going to work, it should be a work injury because the only reason I'm on the road is because of work, and unfortunately that's not the way it works. So in that case, that's a clear-cut case where the going and coming rule applies, and therefore it's not a work injury. So, and the rule of thumb is if you're driving to work, from your home to work, apartment to work, wherever to work, and then you're driving from work to home, then the going and coming rule applies. So if you're going from home to work, work to home, you're on the road, you get in an accident, then not a work injury, unfortunately. So even if you're dutifully going to work to get your work done and to the benefit of the employer, and the only reason you're there is because of the work situation. So then you start to get into these weird gray areas, and unfortunately the Supreme Court of Ohio hasn't necessarily made this more clear. And what I mean gray areas is there's like a lot of these little tiny things where, okay, well, that's a work injury, but this situation is not a work injury, and it's really kind of a quirky mess. I think the good rule of thumb is there's I guess they call it there's like a salesman exception, and I think you probably would apply this to UPS drivers. Post office is covered by that's not covered by the Ohio BWC. But if you're like a package deliverer, again, for Amazon Prime, anything where you're delivering something like that, and you're an employee, then the going and coming rule would not apply to your situation because that is part of, that's what you do. So you're just stopping and going, stopping and going. You're on the road. So if you get in a car accident and you're a FedEx or Amazon driver, or you work for another kind of mail delivery service, or some kind of delivery thing, you deliver furniture, whatever, then that would not apply. So the going and coming rule would not apply, and then you would have a workers' comp claim in that situation. Usually, now here's the thing: you everything's got to be capping in. You could end up having a hearing officer who feels the rule doesn't apply to you in that way, and then you have to escalate it further. But in those cases, it should be a work injury. Now, then it starts to get sticky, and then they make this distinction between, like, if you're a fixed situs employee or a non-fixed situs. So in that case, you would be a non-fixed situs, and fixed situs is like a weird, fancy way. It's I guess Latin. I actually took Latin at one time. I can't remember it, but I took it when I was in high school 100 years ago. I don't, law stuff, they like to throw in this Latin nonsense to be fancy or something. I'm not really sure what the rationale is, but basically fixed situs is fixed site, so instead of just saying fixed site, they're like fixed situs. Awesome, right? Cool, guys, you're good at Latin. Anyways, okay, boomer. So regardless, so there's fixed situs and non-fixed situs. So so fixed situs is basically, do you work at a place in a location that doesn't change? So I work in a law office. My law office isn't a traveling law office. I don't know if there's even such a thing, but it's a fixed location. So I drive from, my home or whatever, and then I go to work at the law office on 1227 South High Street. It's a fixed location. It's a fixed situs. Now, and the reason I'm bringing up this fixed situs and stuff is the Supreme Court has basically made this kind of weird thing where your fixed situs can change from, even if you're driving to different spots, each of those different spots become a fixed situs. And the only way I can really make sense of this is it's almost like you're driving, every time you go to the fixed situs, you're basically driving to work, so to speak, and then every time you leave that fixed situs, you're going to home, if you want to think of it like that. And so what do I mean by this fixed situs and non-fixed situs thing? So, like, for instance, let's say you're you install cable, right? So you install cable in homes, and you got to go, and you might have to go to many different homes. So in that case, each of those houses could be considered a fixed situs. So let's say you're working for a cable company, X, and you're going to, client A. Okay, so you go from, presumably your fixed situs would be the home base, the cable home base, and then you go into home A, so you're leaving cable home base, and so that's a fixed situs. So think of it, you're leaving from home, for the purposes of this thing, you're leaving from home and then you're going to work. So your work would be home A. So you get home A, if you get injured from going from the home base of the cable company to home A, then they may find that the going and coming rule applies, and then you don't have a workers' comp claim. And then, so let's say you go from home A, you're leaving home A, fixed situs, and you're going to home B. Okay, so, and the weird thing is, the way the rule can be interpreted is, each of those houses, even if you have different houses that you got to go to on each day of the week, so you have 5 or 10 different houses. Monday you have 10 new houses, Tuesday you have 10 new houses. They may consider in that instance each of those houses, for the rule purposes of the going and coming rule, as if they were you're a fixed status employee for the purpose of the going and coming rule. So from driving from point A to point B to point C to point D, as you're on the road, the going and coming rule would apply. It's kind of the way that they may look at it. Now, there's X number of appellate courts in Ohio, and so depending on what appellate court, they may find one thing versus a different appellate court. You might be an appellate district that's, for whatever reason, more liberal, more leaning towards the injured worker, versus one that's more heavily leaning towards employers. So that's something to keep in mind. And then they have all these different little within that. So that kind of, I'm talking about driving, but it could also apply to, and why it could also imply, like, if you're getting injured in a non-driving kind of injury, where you're going from point A to point B and you're working at these different locations. So what do I mean? There's like a line of cases, and I'm just gonna go, because a lot of times when I bring up these topics for these videos, is it sometimes impends, or it's kind of, I'm dealing with that similar issue, either at the hearing level or a court case or something. So it's kind of fresh on my mind, and I'm kind of, I have some actual client issue. So, so that's kind of why this stuff's fresh on my mind, because I'm actually dealing with this at the hearing level right now, and then it'll probably go to the appellate level, maybe a court case, and so that's the deal. So there's a line of these cases, and they have these tests that they apply. So there's this company, or this case called MTD Products, and they employ these exceptions to the going and coming rule, and they define 3 exceptions. That the injury, one, happened within the zone of employment, and I'm going to talk about these 3 things. The special hazard, the injury was sustained because of special hazard created by the employment, or 3, the totality of the circumstances surrounding the accident creates a causal connection between the injury and employment. So the first one, it's kind of easy, the zone of employment. So this one applies more so, and this is kind of relevant for this time of year, because this is when these kind of injuries happen, unfortunately, because we're in Ohio and it snows and it's icy. And what I'm talking about when I preface it with this is, if you come to work, you park in the parking lot, and maybe it was the day it was snowing, or it snowed a couple days and it's melts and now it's kind of icy, or there's freezing rain, there's ice on the parking lot. You get out of your car, you walk into the office, in the parking lot, or on the sidewalk walking up to your building, or you're walking up the steps. You analyze each of those things. So let's say you fall in the parking lot, right? You fall in the parking lot, and this happens all the time. We get clients, it's unfortunate, but this happens where clients fall down in parking lots, and sometimes people get pretty gnarly injuries. So you fall forward, you catch yourself, and you get, a rotator cuff tear, or you fracture your arm, or you fall back and you injure your back in some unfun manner. So the way you got to look at that, under that zone of employment, whether they're going and coming, because you're like, well, I'm going to work, but it's still they're kind of the issue of, well, you're not at work yet. So zone of employment, if that parking lot is either owned or under the control of your employer, so they might not actually own the parking lot. They might have almost those spots where you're parking are designated to your company, or they somehow they rent that space, or it's understood that that's where employees park. If they have some kind of control over that parking lot that you could show by showing some kind of link, then the going and coming rule would not apply usually in that circumstance. So you fall even though you're not at the office yet, and it's in the parking lot, and the parking lot could be, you know, hundreds of feet away. It could be, you know, a mile away. But if it's somehow controlled or owned by your employer, if you could make that connection, then the going and coming rule would not apply, and then it would be a workers' comp injury, assuming. And so again, where does this come up a lot? People falling in parking lots in, you know, the winter months in Ohio, because that's when these things typically occur. So let's say you're walking up the sidewalk. Same thing. If your employer, if it's kind of near their building, or it's understood that you're walking up the sidewalk, and maybe they have some kind of, you know, they're responsible for, or they take it upon themselves to salt it or whatever, and you fall, then you can make an argument. Hey, this is under your, you know, this is under the zone of employment. You have manner control of this place, then therefore the employer should be responsible. Now that doesn't mean you fall on the sidewalk, like anywhere, that it's the employer's responsibility. No, it's got to be pretty close. Usually it's going to be pretty close proximity to the building. Same thing, you're walking up the steps, you slip down the steps. That's easier because, you know, if they're somehow responsible for them, then you know, it's within the zone of employment. Likewise, I mean, then you get into things where you're walking to a fancy building, and you know, they have that marble flooring, tile, whatever, and it's super slick, and then you do a Three Stooges type thing where you woo woo woo, and you fall on your back. I still think that's zone of employment, but the employer may make the argument, hey, it's not our responsibility, it's the building's responsibility, et cetera, et cetera. They're always going to make these arguments, okay? Employer is always going to make their arguments, and employee's rep or attorney is always going to make their arguments, and that's the way it works, okay? Sometimes if there's absolutely no merit, the argument will not be made, but usually an argument will be made. So that's zone of employment. So then the second exception would be the special hazard. And special hazard, I think the big case that they use as an example of this, it's called Ruckman versus Cubby Drilling, and it defines this rule. And here's where this gets kind of wonky, because other cases have differentiated. Other Ohio cases have had similar facts, but they've differentiated it in ways that don't necessarily. They're almost like logistical or logical gymnastics. So again, in that case, it's almost like the court that it's interpreting that rule is there, and that's the way this law stuff. Here's the deal, man. It's created by humans, and they have their own biases, whether political or ideological or moral, and they're going to apply their moral, political, and ideological biases to their interpretation of the case, sometimes contrary to the logic and the way the case should be applied, and it sucks that application goes against you, but I mean that's the way it is. So if you don't like the way a law is being interpreted or something, then you know your options are vote these judges and whatnot out. So if you don't, and in Ohio, if you don't like how this or that or the Supreme Court of Ohio is interpreting that, don't vote for a lot of these Supreme Court judges are pretty conservative, so you don't like that interpretation, then don't vote for these conservative Supreme Court justices. If that conservative values aligns with your values, vote for those folks, but then don't turn around and be like, man, this is wrong. And it's like, dude, you voted for him, so you get what you pay for. Irregardless, so this Ruckman versus Cubby thing. So these guys, I think basically the facts were they're driving across Ohio to these gas sites or something, and on the way, they end up getting in a car accident or whatever. So, and they said because they're having to drive excessively, I guess, even though going from site to site or whatever, gas site, I don't even know if they're going to the gas site. I think they were leaving from home or something to the gas site. So you would think the going and coming rule would apply, but because they were driving, they say these excessive distances, they were saying, hey, the going and coming rule applies. So, yeah, and that's the weird thing. It's like, okay, so then is it like, is the Ruckman versus Cubby supposed to stand for the proposition that if you drive more than X miles, then this special hazard thing kicks in? It's like a distance you drive kind of thing, and the courts haven't interpreted that way. So, bottom line is, if there's some weird thing with the way you're driving, like you have to drive in like a high risk area, a lot of traffic accidents, maybe you're not even driving that much distance, and maybe you could get that rule to apply. And I think there's another case, I think, where they apply this special hazard, where somebody was pulling out of work, and in order to pull out of work, you had to take a left against traffic, and by turning left against traffic, they ended up getting in an accident. And so the court was like, hey, it's a special hazard because it's dangerous to take a left against traffic, and this person got hit, and therefore, because there was a special hazard in that circumstance, the going and coming rule doesn't apply, even though they're going home. Okay, so that's the zone of employment, the special hazard, and then the third one is the totality of the circumstances, and this is like they have in this I guess they come from this Lord v. Darty case, and so it's there's three things. So totality of the circumstances. Anytime in law it's a totality of the circumstances, you'll see that used. That's kind of a legal thing that they like to throw in there. You'll see that the totality of the circumstances used everywhere. You'll see constitutional cases where they're like, under the totality of the circumstances analysis, criminal cases, all the time. And it's basically a way to, you're basically taking factors and weighing them. That's basically all it means, is the totality of the circumstances. Okay. So, proximity, there's three things that you have to consider. The proximity of the scene of the accident to the place of employment, the degree of control the employer had over the scene of the accident, and the benefit the employer received from the injured employee's presence at the scene of the accident. So proximity, are you like close to work, or are you not close to work? Degree of control had over the scene of the accident. Again, this kind of goes back to the zone of employment kind of thing. So is it something that the employer has some kind of control over? Do they manage it? Do they have anything related to that scene of the accident? And the benefit, I mean, that's pretty. What benefit do they derive from your being there or not being there? So how does this apply? It applies many different ways depending on, again, which appellate district you're in, and then also what kind of job you're doing. And there's a line of cases that deal with home health workers. So if you're a home health worker, the cases are kind of, if you actually look at these cases that are outstanding, they would appear to state the premise that, let's look at the zone. Let's look at this totality of circumstances. But if you're a home health worker and you're driving from, different clients' houses, the case law would seem to suggest that if you get in an accident or some kind of injury going from point A to point B, that your claim will not be allowed under workers' comp because of the going and coming rule, or the employer would make they would make an argument, and then they would have some cases that would back their argument. Whether I agree with that argument or not is besides the point. So for instance, there must be there's these cases. It's like Cambridge Home Health Care or something up in Cleveland, up in that district, appellate district, and there must be some weird thing that it's a self-insured employer, which means it's a massive employer. So I don't know if like Cambridge Home Health Care is like kicking back some money to these appellate court folks, and somehow that's influencing their decision or whatever. You know, there's a lot of weird stuff that goes. I'm not suggesting anything like that, but sometimes, you know, the things that get lost in history surrounding laws and rules, how they get created, there's a lot of background stuff that you're not privy to unless you really dig into it, and you'd be like, wow, that's the reason why that rule was made. Not really because of the rule, but because of this and that stuff going on in the background. So you'll have a lot of that stuff going with this case law, how it comes up. But regardless, there's some big employer, a home health agency up in Cleveland, and there's a couple cases, and so one of the cases, I don't know off the top of my head what the case is called, but the person they're doing their home health stuff, stopping at their houses, and that the last stop they made for that day, it was an apartment complex, and they are walking out of the apartment complex, and they trip exiting. You know, they open the doors and they slip on a mat or something, and they get some kind of work injury. So under the normal circumstance, if you're leaving work, if that was like their fixed situs, their home base or whatever, and like and that's the other thing, if I'm leaving, coming to work, I haven't even checked in, jumping back to the zone of employment, I haven't even clocked in yet, okay, and I slip in the parking lot and I hurt myself on the ice, I haven't even, I haven't even clocked in, still work injury, okay. And likewise, I clock out and I'm walking out, the parking lot, the big massive parking lot, and I slip on ice or whatever, work injury. And why do I say it? Because this happens all the time. We get claims allowed for this all the time. And I'm walking out in my parking lot, and I happen to get hit by some other genius who is hot to trot to get home. Work injury. Okay, that'd be a work injury and a PI situation. Personal injury, auto accident thing, motor vehicle situation. But that's the way you got to look at it, okay? So, doesn't mean you have to be clocked in. That has nothing to do. But going back to this situation, if this person was leaving work and they clocked out and their slip and fell, that would be a work injury. But in this case, they looked at this totality of circumstances. Okay, proximity of the scene of the accident to the place of employment. So you would think for the purposes of this sort of thing, well, the scene of the accident to the place of employment was, where this person was doing this home health checkup on this person. So you'd think, okay, cool, it's really close. I mean, you could look at it that way, but the court also might say, well, the scene of the accident to the place of employment meaning home base, Cambridge Home Health Care, office, whatever. So they may either look at it as office building is the place of employment, or you can look at where that person did their work. So for this purpose, let's make it simple. We'll consider where they did their work on that patient in that apartment building. They're very close to the place of employment. Okay, so that's a plus. Okay, so and this is a balancing test. Okay, so we got a rock here. That's a plus. So proximity to the scene of the accident. So we got one. Okay, so the degree of control the employer had over the scene of the accident. This is a massive negative, because it's not like Cambridge Home Health Care is going over to each of their patient clients' houses and wiping off, sweeping off water and salt and ice and snow and making sure it's perfect and there's no cracks in the sidewalk and whatever. So they have this instance at 0. Okay, so you're like, okay, so you got a plus because it's really close, and you got 0 because they have no control over the scene of the accident. So then the third one, and I could see, and I'll give it to him, like the degree of control. I mean, I agree with that. What control do you have over this apartment building. None. Okay. So the third one, benefit the employer received from the injured employee's presence at the scene of the accident. So, in my line of thinking, the benefit to the employer, so you're a home health company whose sole business model is dependent upon nurses and home health aides and whatnot going from the client's home. So it's absolutely, in my opinion, the business model is completely contingent upon the home health. I mean, unfortunately, we don't have teleporters invented yet, so they have to get to this place. And so it would be my argument that it's absolutely to their benefit. I mean, their business model would be completely, it wouldn't work otherwise, because if the nurses aren't going there, then it's called, you're in a hospital or a nursing home. Okay, so instead of a nursing home or hospital, you're going to the client's house. So I would say their business model is completely contingent upon their employees, their nurses and home health aides going to their clients' houses. Now, these Cleveland cases would not look at it like that. In that particular case, what they said is, hey, there may be a little bit of benefit, but really the person was going home. And the determinative fact in this situation was it was that nurse's last stop of the day. So remember when I went back at the very beginning, I said at the very fundamental level, the going and coming rule is you leave home to work and then you leave work to home. And from those spaces from home to work and work to home, if you get injured in that area, that it's not covered, the going and coming rule applies. It's almost like they're breaking it down in that manner. So they're basically, for the sole purposes of this rule, since that person was going home, there was little benefit. She was done for the day, and so there's not a lot of benefit or there wasn't benefit to the employer. Therefore, the going and coming rule apply. The totality of circumstance tests applied, said, hey, the going and coming rule applies, and not a work injury. So that unfortunate soul had to rely on their own health insurance and et cetera to deal with their issue. Okay. There was another case, and I'm not sure if I'm getting this. If there's a few cases, there's a number of cases with these nurse type deals. One case, and it seems to be kind of intermixed. The cases that I've seen with these nurse things, it's that one case where the person's going home. There was another case where the person was going from. They had to go to a client's house. And I think they were done with client A, and they were going to client B. But between client A and client B, they ended up with their granddaughter. So they picked up their granddaughter, or they were taking their granddaughter somewhere, and they were going to drop off their granddaughter. And in the midst of dropping off their granddaughter, which was an errand, they got in a car accident. So I would say in that instance, I kind of see it's kind of like you're going on like a personal errand or something. So I can kind of see why that shouldn't be a work injury, But they had another case that I've been that it's called bone dry. I think it's called bone dry waterproofing. This is a 10th district case. So if you're in Franklin County, this would be where you would go to the 10th district. So in that case, and the facts were such that guy worked for a company called Bone Dry Waterproofing, I think, and what they would do is they apply this waterproofing paint or sealant to basements, I believe. And so this particular employee, that was his job, is he would apply this thing. So he would drive to home, to the different homes. So his fixed site was the houses he was working at. Okay, and so in that instance, it was actually his day off, and he had his brother in his truck, and he was driving to Bone Dry Waterproofing, the office, and he was picking up his paycheck. So he goes and he picks up his paycheck, and they're like, "Hey, dude, FYI, we've got 3 jobs today. You want, can you do these? And he's like, yeah, I could do them. And but one, he had his brother. I guess they're gonna go fishing or something that day in his car. So it's not like he's gonna be like, bro, come on, you can, have job shadowing day. You can watch me, do my job. And your brother's like, awesome, dude. That's thanks, man. So obviously he's gonna take his brother home. But the other issue was, for whatever reason, this guy, and to do his job, he had to use paintbrushes, I guess, and he would keep his paintbrushes and maybe some other equipment in the garage in his house. So, in order to he was driving to Powell, Ohio. So I think the place was in Columbus, and he's driving to Powell. And so at first he's gonna stop at his house to get his brushes and stuff. I don't even know if he dropped off his brother yet, but he's driving home, and then as he's driving home, he got in an accident, and then so he filed a workers' comp claim, and the argument was, hey, I was, in the course of employment because I was going home to get my paintbrushes in order to go further on to these 3 locations in Powell to do this job, and so the court was like, well. Obviously proximity to the scene of the accident to the place of employment. He wasn't. I mean, he wasn't near the job sites yet. Degree of control. The employer had ever seen the accident. The employers never have control over the highways and the roads, unless you're like ODOT or something. I don't know. Maybe if you're, whatever. Maybe if you're working on the side of the road and you get hurt on the side of the road, then you'd have control of the scene accident, I guess. I don't know, whatever. Anyway, so in that case, the negative factor, negative, number 1, negative, number 2, negative, and then benefit the employer. And this is where there was kind of some, argument, because you would say like, well, dude, it was his day off, man, and he's going home to get the equipment in order for him to go, do these jobs. It's totally to the benefit of the employer. He wouldn't have been on that road but for these gigs. He would have been somewhere else. But the way the court looked at it, because he had to get his brushes, the court said, well, the reason, his choice to have these paint brushes at his house, that's his, that's his prerogative. I mean, that's to his convenience. That's so he didn't have to drive to the company office and pick up these brushes and whatnot. So that's his deal. You know what I mean? That didn't benefit us. That benefited him. And that had no benefit to the employer. He could have, bought these paintbrushes and got refund from the employer. He could have gone to the employer's warehouse and got this equipment. So the fact that he stored them in his house, that's to his benefit. And so the reason, him going to his house to get these things. So under the totality of the circumstance in that situation, not in the, going and coming rule applied, and it wasn't in the course of employment, and therefore workers' comp didn't cover it. So, bottom line is, there's many cases, and this is an area of law that there's no real clear-cut definitive answer. So there's room for argument on both sides, employers and employees. I think. And again, it depends on what kind of work you're in. I think if you're delivering packages, or you're a salesman, or you're a tow truck driver, something where being on the road is kind of part and parcel to the job, I think the law is more favorable in those circumstances. But if you happen to be one of these people where you are on the road, but your work doesn't necessarily involve something related to being on the road. So, that is, you do your job at a location, a fixed site, and beyond just delivering packages. So you're either a home health aide, or you're a plumber, or you're a cable repairman, or something of that nature, or cable installer, and you're going from house to house. In those circumstances, it seems like it's more against you, the going and coming rule, in this totality of the circumstances. So, for instance, but maybe if you're like, a plumber, and that particular day, you can maybe argue it like a special hazard created by appointment, because that particular day you had to drive to, 10 houses, and you were going to 10 different locations, and the locations were places you had never been to before, and there were high traffic areas, and there's historically a lot of car accidents, and you had to make these weird turns that put you at risk. Maybe you could say argue special hazard, but just be aware. So this thing, bottom line is, this is going about 40 minutes, and at this point people are falling asleep. But there's this going and coming rule apply, and just because, and I saying this to home health workers because I know there are a lot of you folks out there. Just be wary, be extra careful when you're on the road, and because if you get in a car accident, or for instance, you make a stop somewhere and you get hurt at a stop somewhere, and the reason why you're stopping somewhere, like you're running in to get, you're going to grab a sandwich at McDonald's or something, and you walk into McDonald's and you get hurt. And the reason why you're going to McDonald's is because you had to go to extra home health stops that day, and otherwise you wouldn't have gone there. You would have just eaten at home, in that situation. You just be aware that this, just because you're working, doesn't always make this thing in the course of employment, and this going and coming rule is out there, and it can apply to you. So for that reason, be cognizant of that, and also have your own health insurance. If you need, you might look into getting short-term disability insurance. So if you do get injured doing your home health stuff and the workers' comp doesn't cover you, that you'll have that to fall back on, because the workers' comp, it's not a guaranteed thing. That's the bottom line. It's always the employee has the burden to prove that it's a work injury. So that being said, hopefully this provided some kind of help for some folks. You could always post questions in the comments. You could email me. You go to the website www.maleklawfirm.com. Send me questions or comments there. And then best case, stop in our office. It's a free consult, so if you stop and you talk, I'll talk with you for an hour. I'll talk with you 2 hours, and I've done that, and people don't sign up, and I'm not like, sign up. It's like, no, it's called a free consult. That's what a free consult is you ask me for advice, and I say, hey, this is what you should do. Okay, that's what a free consult is. So you could pick my brain. I will, to the extent that I can, give you some advice. I will do so. Otherwise, it is New Year or Christmas Eve, 2019. So we're gonna be in 2020 pretty soon, and hopefully, if you had some trials and tribulations this year, hopefully next year you'll have a bit more happy times rather than sad times. All right. Anyways, see ya. Kip Malek. Have a nice Christmas.